Good afternoon. Thank you for joining this live webinar, where today's topic is there such a thing as a quick divorce? In other words, must a divorce take long, months or years, or can a couple get divorced quickly, in a few weeks' time? Is it possible? And if it is possible, and I'm saying now it is, how does it work? How long will it take? What does it entail? What can you do if you want to get divorced very quick? On a disclaimer, if the parties want to fight the divorce or one party wants to fight the divorce will obviously take much longer, obviously. However, if the parties come to an agreement and they want to get divorced quickly, both of them, there is no reason why they cannot get divorced in a very simplified and a friendly manner. So let us unpack it. If you have any questions, feel free to post it on the Advocate Mohammed Abdullah Facebook page. I'll be keeping an eye out on that. Alternatively, you're welcome to send us an email with a specific question and we can deal with that question in the future, as we have now received two questions which I have modified a bit. But it deals with the issue concerning a parties who wants to get divorced as speedily and as quickly as possible. How does a divorce work? The obvious first answer would be we can only divorce a couple, or the court can only divorce a couple who are married. Firstly, you have to be married, of course. Married in terms of a legally recognized form, in terms of the Marriage Act, the Customary Marriages Act. Alternatively, also if you are same sex, the law that applies to that as well. And not necessarily any other specific religious or cultural marriage applies to the specific webinar. Example, Muslim marriages, Hindu marriages, certain traditional marriages. I'm not dealing with that. I'm only dealing today with the civil marriages. South African marriages, basically how people term it as being married in court. That's a term they use. Nonetheless, let us unpack it. Firstly, the parties will have to be married, number one, civilly. Secondly, the marriage has to have broken down. No court in South Africa will divorce a happily married couple. That is very important. Your marriage has to be broken down. For argument's sake, you cannot save it. There's problems in the marriage, and you cannot continue this way. There are various reasons or various aspects one can look at. For example, the parties no longer love each other and they want to move on with their lives. They would like to one day meet someone else and continue a relationship with somebody else and no longer be in this current relationship. Another way of looking at it could be that the parties are not living together for the last year or few years and they have no interest in living with each other. And maybe lastly, there are certain issues in the marriage, serious issues in the marriage, which would obviously cause a marriage to break down and being unable to be saved. For argument's sake, one of the spouses is now living with someone else and involved with another person. One party may, for example, want to continue with the marriage, but the other party decides no. Those are the various factors, but the bottom line is the marriage should have problems in it and the marriage cannot be saved. So those are two aspects. Firstly, you must be married, and secondly, there must be problems. And the third aspect, if there are minor children involved, the court will not divorce a couple unless the court is satisfied that it is in a minor child's best interest. So those are the three general principles. There are a lot of other legal principles that applies on the process of a divorce, which we might touch on while we proceeding further. Okay, so before I deal with the questions, my apologies. Firstly, how, in summary, would a quick divorce take place? The ideal scenario would be the husband and wife comes to the attorney's office. They agree on various aspects. For example, that the marriage has broken down. If they are married in common property, they agree upon the division of the joint estate. If there are minor children involved, they deal with issues concerning care and contact, child maintenance, etc. And if there's a pension involved, they deal with the aspect of the division of the pension, but should one party receive half the pension or will you keep the pension? They'll deal with issues regarding the home, if the parties own a home. If they own a house, what happens to the house, and all of that. So that's an ideal situation where the parties agrees upon everything. They sign a settlement agreement. One of the parties takes the matter to court, serves the documentation upon the other party does nothing. You get a date from the court on the unopposed divorce roll and you get divorced. If it was not COVID-19, I would say the quickest technically possible time period for a couple to get divorced without any problems could be about 3 weeks. Yeah, so you serve the summons today, you wait your 10 days, your 10 working days, and then soon thereafter you set the matter down. Some courts allow for waivers, where the defendant might say, I'm not opposing this divorce, I'm waiving my rights to the expiration of the 10 days, so 10 days does not have to expire before the plaintiff they set the matter down for the unopposed divorce roll. He waives his rights, and some courts are fine with that, and the matter can be set down much shorter. But theoretically, for everything to be above board and for there to be no problems going forward, I would say the shortest possible way would be 3 weeks, 3 to 4 weeks, depending upon some facts and circumstances. Sometimes it takes a bit of time for the parties to get served with a divorce summons. Okay, so that's what it entails, a quick divorce. Let us deal with the first question. My husband and I are married out of community of property and profit and loss with the exclusion of the accrual regime. So basically, that means what's yours is yours, what's mine is mine. A divorce or a death, whatever the parties own still belongs to them. Debt, assets, liabilities, that's debts, whatever the case may be. We have no children and both agree that the marriage has broken down and cannot be saved. We tried counseling and it did not work. Is it possible for us to get divorced in the next few weeks? That is the easiest and the most simplest scenario for a divorce. They are married out of community property. There is no accrual that needs to be calculated afterwards, so that's easy. There are no minor children involved. So there's no issues concerning the family advocate consent papers, the court applying its mind regarding what's in the minor child's best interest, no custody dispute, no maintenance disputes, and so on. There are no property issues that needs to be involved as well, as I mentioned earlier on, because they're married out of property, and the marriage has broken down. They have obviously seen counseling. Under those circumstances, there is no need for the parties to enter into a settlement agreement or consent paper. The plaintiff can seize attorney, issue summons. The other party has to do nothing, because all that will be asked for in the decree of divorce order would be for a decree of divorce, nothing else. There's no issues regarding property, there are no issues regarding minor children, and that's it. So that's a simpler scenario. But the question is it possible for us to get divorced in the next few weeks? My apologies. It is theoretically possible, depending upon the court, based upon COVID-19. For example, here in the Western Cape High Court, you will have to approach the registrar for a date for the unopposed divorce roll, and that is about 2 to 3 months from now. So it will take some time. However, if there were no such issues, no COVID-19, no lockdown, and so on, you could have gotten divorced in the next 3 to 4 weeks. So that is possible. So that deals with the first scenario which you are dealing with. It is possible for a couple to get divorced very quickly. Let's say the parties had minor children involved. Obviously, a parenting plan would have to be entered into. In that parenting plan, they'll deal with the issue concerning care, contact, maintenance, whatever the case may be. That would obviously have to be taken to the Office of the Family Advocate to be endorsed. So that might add a day or two for that to take place. Nonetheless, it can still be done within the 3 to 4 weeks' time. If there are pension funds, if there are immovable property, that shouldn't be a problem at all. You stipulate the details of those specific items and it gets dealt with in the settlement agreement or the consent paper. So you will have a consent paper dealing with the property aspects of the marriage, house, pension, car, whatever the property aspects of the marriage is, and then you will have a parenting plan that will deal with the minor child. Or you can all have it in one. Consent paper can deal firstly with the property, and secondly, you can deal with a minor child. Question number 2. I have been trying to get divorced from my wife for the past 3 years. COVID-19 caused much of the delay. And I would agree with a specific commenter. COVID-19 has caused a huge delay in divorce matters. Firstly, the courts were closed for some time. Remember that hard lockdown we had initially? The courts, they were open theoretically, but they were not dealing with the normal day-to-day matters, for example, unopposed divorce. Then there was a bit of a backlog, and now you have to wait a long time to be heard when it comes to an unopposed divorce. Regarding this specific client, here he's dealing with an opposed divorce scenario. The same situation, courts have not at least been dealing with matters which were not seen as being urgent in nature at the start of the lockdown. And obviously with these waves coming up and coming, the first wave, the second wave, the third wave, it also causes a bit of a slow movement of the wheels of justice. So I agree with the specific commenter that COVID-19 would have caused a bit of a delay. Nonetheless, the questioner goes further. He says, however, we cannot agree on anything, especially primary care for our minor child. I want shared care. Now, the moment a party cannot agree upon something regarding the marriage, one would be the care and contact of the minor child. That automatically causes a huge delay in a divorce, because ultimately a judge will have to decide whether or not primary care should be given to the mother, the father, or there should be shared care. Now, to get a judge to hear this matter, to deal with your matter on the day solely, you'll have to wait many months, sometimes years, to get a judge to hear this matter. Depending upon the court, depending upon the court's role, how backlogged the court is, which province you're in, which suburb you're in, which city you're in, etc. But you'll require a single judge to deal with the matter. Therefore, the matter will have to be on the opposed court role, run trial. You might require family advocates report. There's a lot of other things that has to take place, for example, discovery of documentation, a lot of processes that will have to take place because the matter is opposed, as opposed to an unopposed divorce, which is simple by agreement between the parties. We are married, income into property. We, however, do not own a home or have pension funds, which simplifies matters a lot. There are no property aspects to argue about. Because they are married with each other, income into property, there should still not be a property issue to be argued about, because the joint estate must be divided in any event. So when it comes to property aspects, there is no reason for divorce to be delayed. For example, the wife will say, no, I want the house, you should take the car. If the parties cannot agree upon that, the court will appoint a liquidator, or they call it a receiver, and that specific person will liquidate not your estate, the joint estate. He will divide the joint estate fairly. Usually property gets sold and the proceeds are divided equally between the parties. The question this person has is, how can I speed up the finalization of the divorce? Looking at the question, I see the stumbling block here is shared care and contact. That's the only problem which I see. And usually, if an expert gets on board, a professional like a psychologist, a social worker, whatever the case may be, they can advise the parties what they believe is in the minor child's best interest. You may approach the family advocate's office as well. They might take a few months to do an investigation. Nonetheless, that time spent with a professional, the family advocate, the social worker, the psychiatrist, the childcare expert, in investigating the matter, consulting with the mother, consulting with the father, speaking to collaterals, meaning third parties, other people, speaking to the minor children involved if they are mature enough to communicate, etc., may resolve this issue. If the parties cannot resolve this issue regarding primary care or shared care, unfortunately, a court will have to make a decision, and you'll have to join the queue to get a court date. You'll get a court date, but the court date might be in many months' time. So in conclusion, in summary, basically, it is possible for a quick divorce to take place. Either parties cooperate or one party does nothing and the matter proceeds. And that could take, with COVID-19, best case scenario in the Western Cape at least, I would say about 2 months, 2 to 3 months. Under normal circumstances, it can take, for example, 3 weeks to 4 weeks maximum. If the parties cannot agree upon one aspect of their marriage, and material here would be the minor child, then I would say it can take many, many months, and you'll have to get your foot into the queue. But before you can get your foot into the queue, various aspects have to be dealt with. For example, discovery of documentation, that pre-trial conferences, and those things need to take place. And in order for your matter to be certified, trial ready, the judge will have to be convinced that should the matter proceed on the court date, there will not be any outstanding issues. Nobody will stand up and say, Judge, I got a document I want to submit, or Judge, I have a problem with this, or I have an issue with that. The court will have to be satisfied that we're not here to waste any court time. And if the court allocates a date for you for trial, on that specific date, the court will hear the matter and the court will finalize the matter. Thank you very much for watching. I appreciate it very much. It's always good to have people watch these videos and comment. And I hope you have a lovely day. Thank you.